because you have to, and another point I want to make, and I made earlier this morning, but let me reiterate it again. We are trying in difficult financial times. Creditors have never been more hurting. And the banks are going, when all these adjustable rate and variable mortgage come due, it's going to hit the fan. And that's going to happen in the next 18 months. There's going to be even more banks go out of business, and there's going to be a lot of banks sitting around with property that they don't want and they can't sell. And I think there's going to be a lot of negotiation and settlement. So I think it's the best time ever to do asset protection planning. The other thing I want to emphasize too is from a marketing standpoint, everybody I talk to, almost I'd say 80 to 90% of the people that I talk to in the estate planning area, and I get around a little bit nationally, their traditional estate planning practice has fallen off a little bit. And the people that are doing the $3,000 to $5,000 estate plans are putting those off until next year or the year after. And therefore, as estate planning attorneys, we need to be able to supplement our practice. And asset protection fits right into that. And in this, the Rainmaker Institute tomorrow night, and in the programs that we give throughout the year, I'm going to talk about how you can market your practice and tie it into asset protection planning, to business planning, and maybe even some other areas. So I think you'll be interested in that. Okay, let's move on here. With respect to the asset protection, with asset protection trust, it depends on three factors: level of the settlor's control over the trust, the extent of the power of appointment available to beneficiaries, and the extent of the withdrawal rights provided to beneficiaries. And those are the three things that you have to keep in mind when you draft the trust. When Lisa goes through the drafting, we'll touch on these issues. Okay, for maximum asset protection with a domestic asset protection trust, we insist that there be an independent trustee. And we've got one or two clients who have put in a non-professional trustee. And we make them sign a letter that we've advised them not to do that, we've advised them to have a professional trustee. We think that if you have a professional trustee, it looks better, it smells better, it tastes better, and the proof will be in the pudding. You'll have more protection. One of the problems with that for some clients, and even real wealthy people, is they don't like to pay the trustee fees, because the trustee fees are expensive. I'll tell you right now, that's one reason we use Nevada, because the trustee fees in Nevada are much more reasonable by several thousands of dollars. And the trustee fees in Delaware and Alaska and South Dakota are usually in excess of $5,000, even when the trust is just holding a custodian interest in the member LLC. In Nevada, it's $1,500. It's a big difference. And when you have several LLCs that you're paying, California, I mean, we're so greedy. The state government in California is so greedy there, they charge $800, a special $800 tax, even if it's a Wyoming LLC with Wyoming property. If it's managed by a California resident, they still collect the $800. So the Franchise Tax Board in California says that you're doing business in California if you manage an LLC, even if the property is not in California, and even if the LLC is not a California LLC.